Do I have to enforce my copyright? That's a question that I got from a viewer last week, and I'm going to answer it here. I'm Angela Langlotz, trademark and copyright attorney, and I go live here on weekdays to talk trademarks and copyrights. Now, somebody asked me, Angela, do I have to enforce my copyright? Now, just for those of you who don't know, a copyright protects your rights over your creative work. It gives you the exclusive right to perform, to distribute, to make copies of your creative work. What kind of works are covered by copyright? Well, it could be any creative work. It could be a video, it could be a poem, it could be a screenplay, it could be architectural plans, it could be computer code, it can be a whole bunch of things, photograph, a sculpture, a painting. There are many, many different types of creative endeavors that are covered by copyright law. So what happens if somebody infringes your copyright? Do you have to go after them and make them stop? The answer is only if you want to actually remedy the copying. So you have 3 years after the date that you discover the copyright infringement to sue for copyright infringement. So if you want to bring somebody into court, you have 3 years to do it. The other thing that you need to know is if you want to get into federal court to sue for copyright infringement, you need to have a copyright registration. The Supreme Court recently ruled that you can't get in to federal court to sue for copyright infringement if you don't have a copyright registration. This is a little bit confusing because on the one hand, you have copyright protection just because you created it, and it doesn't matter whether you officially register that with the U.S. Copyright Office or not. You still have the rights. But the problem is you can't get into court to redress or remedy the usurpment of those rights unless you have the registration. So it's a little bit weird that you have to have the registration in order to sue, but that's what the Supreme Court has ruled. So what should you do? If you have something that you really care about, that you want to protect, go register it with the Copyright Office. It's not a very expensive process, but the process to register is a little bit confusing, so you may want an attorney to help you. And then once you get the registration, you'll be given a certificate and it'll be on record with the Copyright Office. There's also a deposit requirement for some sorts of work. So if you write a book, for example, they want you to deposit 2 copies. One of those goes to the Library of Congress so that your work in perpetuity will be kept as sort of a permanent record of the intellectual property, at least some of the intellectual property that's created here in the United States. So bottom line, yes, you do need to bring suit to address the copyright infringement within 3 years, and you need to have a copyright registration. If you have any questions about trademark or copyright law, you can message me, Angela Langlotz, on Facebook. I'm at facebook.com/trademarkdoctor. You can also find me online at TrademarkDoctor.net. I have a huge library on YouTube. Just go to YouTube and search Trademark Doctor, and you'll find hundreds of videos about trademark and copyright law. You can find me there.